So we are now going to look at topics 4 and 5, and these are distributions, so rewarding shareholders, paying return to shareholders, and also reductions, redemptions, and the solvency test. So this is week 4, and we're going to look at the slides for week 4 and the slides for week 5. We started out by examining a really interesting case called Pilmer and Duke Group, and that illustrates how hard it is to conceptualize capital and work out what capital is. And capital is an entry on the balance sheet, and it's the money contributed, or it remembers the money contributed by the shareholders when the company was first set up. It is therefore not an asset. It is just a figure on the balance sheet, and it's a technique designed to ensure that shareholder claims are ranked below the claims of creditors while the company is going concern. And we looked at how this is done by looking at capital on incorporation. Let's look at year 2, where you can see the company has a healthy asset profile, some cash, some receivables, some securities, some inventory, some land, some patents. And we can put on the other side here a bank loan, other liabilities, plus the capital. Now that was the money originally contributed by the shareholders. And we can see that this company has a surplus of 40,000. And question is, how much can it distribute? Now, if you look just at the asset side, you'll see good amount of liquidity, healthy receivables. We don't know much about how liquid those securities are, inventory, land, and patents. But in any event, what we can see is that we've got here enough, or we've got liabilities worth of 10,000. And the company at the moment has enough cash to pay down that liability. So it's, from a perspective of creditors, in a very healthy position. Nevertheless, it can only distribute 40,000 because share capital, the buffer here, reduces its ability to distribute more. So that's how capital works. It's a buffer, but not in the sense of an asset, just in the sense of a blocker preventing distributions. So that's how capital works. And the idea is that we are looking after creditors by limiting the ability of the company to make a distribution. We looked at the profit calculation rules. We said that capital is also the premium, or rather capital, the share premium account remembers the premium paid by the shareholders. And then we spoke about rules that try to prevent the circumvention from the distribution of the distribution rules. Those are the rules on prohibiting dissipation of corporate assets. And we looked at them in some detail. And then we talked about remedies. So when companies can claw back distributions, either from the directors or then from the shareholders. And directors are liable if they have authorized a distribution that was illegal, and it's not necessarily the case that they've acted on the advice of an accountant. That doesn't necessarily cause them to have a defense. And shareholder liability, so the shareholders have to give back a dividend paid to them that was unlawful if they knew or ought to have known the facts which mean that the distribution contravened the act. So they don't have to be knowledgeable of the law. You can claw back a dividend from a shareholder when they knew about the facts, when they knew, for example, that assets were not worth as much as it was stated. And then there's sort of a knock-on topic which we didn't cover very much. So this distribution rule is a rule that is designed to protect creditors, designed to prioritize creditor claims and put them before the shareholders can receive a return. And that is done through comparing assets and liabilities and then adding an additional sum as a liability, which serves as a blocker for distributions. So that's the logic of the capital maintenance regime. Now going back then, talking about going all forward actually then to reductions of capital share buybacks. So we've remembered here how capital works, and there is sort of, again, two cases, one very old, the other one, Trevor and Whitworth, is 19th century. Barclays Bank and British and Commonwealth Holding is sort of late 20th century. So those cases are, why do we care? Well, we care because shareholders are paid after creditors have been either paid or looked after. And the situations that we need to worry about are a distribution, but also reducing capital, which we can reduce in three forms, and we spoke about how these operate. There's also a question of class rights. So what needs to happen? Well, for a reduction, the members have to agree and the court has to confirm that reduction. And it does so on terms and conditions as it thinks fit. So the idea is, if your buffer becomes smaller, the members have to approve, but also the court has to approve it and can impose terms. The design of those terms is to adequately protect creditors, and we spoke about two examples of such terms. This was a reserve created for an asset that, so in Jupiter House Investments, that was sort of an asset where they thought they may have a claim against their solicitors for damages. So if that claim was going to be successful, they would have to put an entry on the capital side, preventing them from distributing that. Now then, this conveniently leads over to another way of reducing capital, and that is a way that applies to private companies only, and that's reducing companies through a solvency statement. And that way already exists. It's just for reductions. It's not for distributions. But it opens up the general question, should we broaden the application of the solvency test and use it also for distribution purposes? Now, looking at this solvency statement, which is here, so distributions, very important, I think. The solvency statement continues to prioritize creditors. So we're not talking about something radically new. We're talking about another method of prioritizing the creditor's interests. So that's really, really important. It is just another method. Currently, we use the distribution rules in section 830, and we have capital as part of that. And this would be working out using another test for giving priority to creditors. And that puts the directors at the center of the stage, and the directors have to form an opinion to determine whether the distribution compromises the ability of the company to pay its debt. So a solvency statement is a statement by the directors. And that statement is reviewing the company's situation at the date of the statement. And the directors certify that there's no grounds on which the company could then be found unable to pay its debt. And there's sort of a time period of 12 months attached to this. And so that is radical in the sense of it allows a reduction of capital at present, and in the future could allow a reduction, distribution on the basis of the directors carrying out an analysis. And the analysis would be, how is the company's financial position right now? What will it be like in the future? Is there a risk that the company will be unable to pay its debt in the next 12 months? And if there isn't, then the distribution can happen. Or right now, the reduction can happen. So it's an analysis of the financial position now, but also going forward on the basis of what directors know about the company's future position. So that's the solvency statement. We talk about acquisition of shares. Now let's look at the general policy overview. What are we trying to achieve? Well, we've got the problem, limited liability causes creditor interests to be affected. Ideally, we wouldn't worry about that because creditors can price the risk. So they can lend on terms that protect them. But of course, there's market power asymmetries, there's information asymmetries. Contracts are very hard to write for the future. And moreover, companies can, after the contract, change their strategy and affect their ability. So limits to self-help. There's also a collective action problem, which I won't go into. Plus, they're involuntary creditors. So this slide is there to say we need to worry about creditors. Not all of them, but certainly some. And here is how the current regime works. So it sets out as a summary of the current regime. And if you look at which type of creditors are protected, current or future creditors, adjusting, non-adjusting, long and short term, and then critiquing the current regime. Let's go through this. Now, current creditors are definitely protected by the current regime because their debt is recorded as a debt. Future creditors are protected to the extent that accounting rules require the company to provide for them. So that depends on what the accounting rules do. And the test is along the lines of, is this more likely than not to be a liability? But of course, beyond that, if you know about a liability that may happen, but is not more likely than not, current rules don't protect you. So long-term future liability isn't something that you need to take into account currently. The current regime protects adjusting creditors, well, in as much as there's disclosure, but not beyond that. And the idea is really to provide for non-adjusting creditors because you create this entry on the debt side, so you have to keep more assets than you need for your current creditors. And therefore, there's a bit of kind of, there are more assets there than you actually need. Now, there is a sort of an idea that the current regime protects long as well as short-term creditors, and that's true. And that's because any creditor no matter when the debt is due, is recorded, any creditor's claim is recorded on the company's balance sheet. But of course, what you do is you compare that debt with the current assets. So that isn't quite right, because those assets won't be there when the debt is due. So it is a protection of future creditors. Now, another criticism is, of course, liquidity isn't the focus of it. It's sort of the focus of the distribution rules currently is comparing assets and liabilities, and we don't look at whether or not there's enough liquidity to pay debt as it falls due, or we don't know enough about that. So here are the alternatives, and that's from the Rickford paper, so you've got his menu there. And the question to you is, which one works best? What are the advantages? What are the disadvantages? And should we forget about the distribution rules and have a solvency test? Or should we have maybe both? Or should we improve the current distribution rules by adding more consideration of liquidity? Can they even be improved? Or alternatively, of course, the sort of general theme is that the solvency test is a much better way of determining whether distribution is a good idea from the perspective of the creditors of a company.